SJC-12287, Kiribati Seafood Company, LLC v. Dechert, LLP.
Ms. Delahary, we're very upset at council for not suggesting that this should be done with a view. So, but,
Maybe next time,
okay.
Chief Justice.
All right.
May it please the court, Megan Delury for Kiribati Seafood Company. There were many claims addressed on the cross motions before the trial court, but on appeal, Kiribati seeks to restore only one claim. Its claim for legal malpractice for Dechert's failure to submit evidence of the financial consideration for the assignment of the subrogation interest as requested by the Tahitian court. The absence of that evidence was identified by that court as the reason it vacated $1.76 million of the award that had been given to Kiribati by the commercial court in Tahiti, the trial court. I'll start with the trial court's decision, although the parties seem to agree that it has different errors. The error that we have identified in our briefs regards the lack of consideration of the foreseeability of what Dechert claims was the error committed by the Tahitian Court of Appeals. The trial court determined that that decision that the appeals court issued at the end of the day was erroneous, and as a matter of law, Dechert could not be held responsible for the malpractice which the trial court was required to assume Kiribati could prove for purposes of Dechert's motion for summary judgment, which focused on causation. The trial court's decision stands for a bright-line rule, extraordinary in the law of negligence, that judicial error, that is an unintentional conduct, a mistake by the court, is always a superseding cause, and that lawyers can never be held accountable for their negligent conduct in a case where an error of the court is present.
Basically, what you're saying is, I gather, that no matter what, even if the first Tahitian decision was wrong and requiring an additional showing, the fact that the evidence that the client provided to the lawyer should have been given over because it was foreseeable?
Precisely right. That's exactly right. The Tahitian court's decision specifically said—
Or wrong.
Right or wrong. Now, we do take issue with the determination that the French law, that the Tahitian court did not apply the law correctly, but right or wrong. There was an interim decision in that case saying, we accept that the assignment is valid. Now we're going to look at the double recovery policy under French law. And to that point, we want to—
Now, go back to that. I know that I didn't go back to DUF 82. Is that in French or English, by the way?
I believe it's in French.
Okay, and it's translated for us? Do we know specifically what it says?
The double recovery policy?
Where you write in, I guess, when the red brief, page 17, that it deferred ruling on the subrogation award and requested the Kiribati submit evidence of the consideration provided to Lloyd's, and the court suggested that the evidence was necessary to avoid a double compensation for the same damage. I assume that is the essence of your foreseeability claim, is it not?
That's right, Judge. That's right, Chief Justice. So the appeals court decision, the interim decision, is in the record translated into English, and it specifically says, we accept that the assignment was valid, but the transfer deed, as that court referred to it, the assignment instrument says that there was consideration. And under French law, we want to see what the evidence of consideration was. We want to see the financial counterpart, in the words of the Tahitian Court of Appeal. And in fact, the record shows that within days of receiving that interim order, Dechert emailed counsel for Kiribati saying, this is what has happened, and we now need to provide evidence of the financial consideration. That same day, Mr. Moran, Kiribati's United States attorney, emailed that evidence to the lawyers, and it consisted of the very disputed evidence that we believe should have been submitted. The fee payment records showing that there were fees owed by the insurance company that had not been paid. The fee agreement showing that they had agreed to split the fees 50-50, further demonstrating that the insurance company owed the fees.
Yes,
yes.
But here's the thing about that. Do we know, or is it purely speculation, as to what would have happened if that evidence had been provided, as should have been?
I think not, Justice Link, for two reasons. First is we have, unlike a personal injury case where the broken leg can't tell you what broke it, we have here the appeals court decision saying very precisely why it has ruled the way that it did. It specifically identifies the lack of evidence on the legal fee dispute as one basis for its ruling, And the other basis that it identifies is although Kiribati maintains it has these claims against its insurance company, it's 6 years later and it's never brought a claim. But the evidence that should have been submitted to refute that was that a release had been given years before, in 2004. That was part of the consideration for the assignment.
Is there any dispute about what materials the client had provided to Dechert?
There is not.
Okay.
That was admitted in the 985 statement.
Okay.
So they had those materials. There's no argument advanced by Dechert that we made a judgment call. We didn't think those materials would support our argument. We thought those materials would hurt us on another part of the case. There's absolutely no evidence of that.
It's clear in your view, is it, that had those materials been submitted, the decision then rendered by the Tahitian court, whether right or wrong, would have been different?
Yes. Yes, we believe it is clear.
And that is contested by your brothers.
Well, their view of the case, so the argument that they advanced on causation is somewhat different than the argument that they advanced below. And in 2 pages of their brief, they argue that there is no causation in fact in this case. And the way that they demonstrate absence of causation in fact is unique and I believe unsupported in the Massachusetts cases. But for cause, of course, the typical way of doing it is we say if we eliminate the defendant's negligence, what would have been the result? If we eliminate the defendant's negligence and the result is the same, it can't be a cause in fact.
I'm sorry.
Yes.
What do we do with the expert testimony decision made by the trial judge?
Yes, I'm coming to that next. So in this case, if we eliminate only Dechert's negligence and we say they provide the evidence, then it's clear, we think, from the interim order and the final decision that they are the cause in fact. With respect to your question, Justice Gaziano, about the experts, the law in Massachusetts is that you do not need to have expert testimony on the standard of reasonable care or causation. I recognize that there are very few cases where a plaintiff can get to the trier of fact without an expert on breach of the duty of care. In this case, we think that this is one of those cases where the breach is so obvious that expert testimony is not needed.
Well, if you lose on that point, you lose the case, is that right? If we decide not to reverse the judge's decision on the expert testimony, you lose. I hear you saying that it doesn't matter, but that this is negligence that's so obvious, I'm just not sure about that.
I think it's true that if you disagree that the negligence is obvious and you affirm the decision to exclude the expert, that there's a problem in the case. Absolutely right. But I think that the negligence in this case, again, we had an order of the court, not to mention that this is consistent with the advice that Dechert gave to its client at the time. Years before we get to the appeal, at the time that the subrogation interest was transferred, there was...
So are we using Massachusetts law or French law to determine whether there was negligence? I understand that the French standard is due diligence, so that's not exactly reasonable care. It's analogous, but how do we know that it's the same?
I don't think there's been an argument advanced that the standard of care itself is substantially different.
Okay, so you didn't need an expert on that. That was agreed by the parties.
I don't think there's any dispute about what the standard of care is. I think Massachusetts supplies the elements of the cause of action in the ways that we prove our case. I would agree that when you're talking about what would a reasonable lawyer do in this circumstance, we have to deal with the system that we are in. But it is an adversarial system, and I don't think the testimony from their expert and from their lawyers on the other side is similar, that they understood what the duty was. But with regards to the expert in this case, where you have Dechert giving advice contemporaneously to its client that this is an issue that can come up, particularly when Lloyd's left the case. There was discussion when Lloyd's left the case, what is the impact going to be? And Dechert gave specific advice. Now that Lloyd's is absent, because they were here and were asserting their subrogation interest, now that they are gone, this is something that the French court may look into, and we need to be prepared to address it. And then years later, lo and behold, the interim order comes about and says, yes, we are going to look at this double recovery policy. We acknowledge the assignment deed. The deed says there was consideration. show us the evidence of the consideration.
Well, you could have appealed this case. Why didn't you?
Dechert advised against it. Dechert advised against it. And I think that is important in this case. There is available, and the trial court cited a Nevada court Supreme case, a defense to a lawyer who commits malpractice. Client isn't required to appeal, but there is a defense available for the lawyer to say, but if you had appealed, it would have shown that the decision would have been reversed. But that defense isn't available to Dechert here because they're the ones who advised against an appeal. What they then do on causation is essentially to say, since I can't make out this defense of what would have happened on appeal, let's pretend that what happened in the appeals court didn't happen. Let's pretend there was no interim order. Let's pretend the appeals court is my next level of appeal. What should have happened in that very proceeding? And that, we think, is the wrong approach to take to causation, in fact, and proximate cause in this case. You can't eliminate other events that happened, particularly events that preceded the negligence. That's what happened in the case, and the duty of the lawyer is ongoing. As practitioners, we always have to respond to what goes on in the case, and our duty is not eliminated because of an order that we think is wrong or is adverse. It would be different if this came at the end of the case, quite possibly, although Dechert did advise that this issue could come up before we even got to the appeals court. But in this situation, they had that interim order, and it gave very clear guidance, not just guidance, instructions of what the appeals court wanted to see. They had the documents from the client. They offer no reason of strategy or judgment that they could not have submitted that evidence to the court. And the Tahitian Court of Appeals said it was the lack of that evidence that caused the loss. So we believe the case is clear.
When we look at the documents which Dechert did not provide, what amount of consideration would be reflected in those records? How much money in consideration would be reflected?
So the consideration was the legal fee dispute. Lloyd's was supposed to pay 50%. As of the time of the settlement, there was an amount owed by Lloyd's of over $200,000 in the nature of $250,000. So at the point in time when the assignment was made, that was money that Kiribati had to pay. The other thing of value that Lloyd's got were two releases. A release related to claims that had already been advanced on this policy. There were sue and labor expenses that had not been paid of a few $100,000. But it also got a policyholder's release. This was an occurrence policy, and it was the wreckage of a ship, of course, that led us down this path of lawsuits. And what claims could have been made in the future were unknown for pollution or whatever else you might imagine could flow from this case. And as long as they related to that occurrence, Kiribati would have a basis to continue to go back to Lloyd's to draw on the policy, but it gave a policyholder's release. That was in the settlement agreement, which was not submitted to the Tahitian court.
So if those documents had been furnished, how do we know that the Tahitian court would not have said, well, you only get the value of that consideration because the amount above and beyond that consideration would still be the double recovery, which French law does not permit?
So then we come back to the expert issue, I think. First of all, the exclusion of Professor Lubsdorff was in our position an error of law. Certainly as to the standard of care, as Justice Hines raised, given that it's obvious in our view, but if not obvious within the rubric of the cases, certainly close enough that the opinion he has to give is fairly limited, and as a professor and a practitioner in many years of Massachusetts, he should be able to give that opinion. As to causation, whether or not the Tahitian Court of Appeals was right, it is certainly within his capacity as a professor of law and someone who has studied the French legal system and French ethics and who reads in French, to read that decision, interpret what it says, look at the law of France, as you know, any lawyer can do the research, and opine, yes, this evidence would have been enough, and that's what he does. It doesn't, whether or not this court believes he's qualified to opine on whether the law was right, whether Tahitian court was right on the law, and we believe that he could give that opinion. Even if we have to say that his opinion is premised on an assumption that it was wrong, there is still a duty in this case to supply what the appeals court requested, and he can certainly interpret that order, look at the law, and say, under this legal framework that the Tahitian Court of Appeals was operating in, this evidence would have made a difference.
But do I hear you to say that you need Lubsdorff's testimony in order to get your full recovery?
I don't believe that we do, because we have the appeals court decision specifically saying what it wanted to see. And I would add that Dechert has offered no expert opinion, as you often see in legal malpractice cases, that it wouldn't have made a difference. Their expert has not opined that even if we submitted this evidence, the outcome would not have been to the contrary, something that we would have expected if that were the case.
I'm referring to the amount of recovery, the 1.76, as opposed to something less than that.
I understand, and it may be that if this court determines that that is not clear, we need to have a trial on the amount of the damages. But we believe that the decision makes abundantly clear that what was necessary was something. We need to see that you've exchanged something of value and that this wasn't just a sham transaction. And they had the evidence, they could have submitted it.
All right, thank you.
Thank you.
Mr. King, good morning.
Morning. May it please the court, my name is Dennis King, and with my colleague Richard Zielinski, we represent the appellant in these proceedings, the defendant below, Dechert, LLP. This court should affirm the trial court's grant of summary judgment in Dechert's favor for two reasons. First, the court properly allowed Dechert's motion to strike the affidavit of Professor John Lubsdorff, Kiribati's purported expert on the standard of breach of the standard of care and causation. Absent testimony from a qualified expert in this case, Kiribati cannot prove its claim against Dechert. It cannot get its claim to a jury, and Dechert is entitled to judgment as a matter of law.
Why is it not the case that when an appeals court says, we would like to see information as to the amount of consideration, and either it says or it is apparent that the reason it wants that is because it might claim that if there were no consideration, it would bar recovery because of a rule of against double recovery, that any fool would know that you provide them the information that they asked for, as opposed to blowing them off and saying, we're not going to give it to you because we think you're wrong as to that legal standard.
All right, let me say two things. First, with respect to the standard of care, what needs to be shown is that a reasonably prudent commercial litigator practicing in France in a commercial case in Tahiti with French law applied would have done something different presented with these circumstances. Then you move to the issue of causation.
So
And
wait,
the-
before you go there,
Stay there, yeah. I
stay
mean,
there.
Anywhere, Russia,
Okay.
Cambodia, when a court says, we need to see this because it may matter in our decision,
And you have it
and
to
you
give.
have it, and it may be able to prove a point right or wrong, where in the world do you say, no, we're not going to give it to you because we think
That
you
is
may
not
be
true.
wrong?
That
That's
is
not
not true. Kiribati did not have evidence that was sufficient to prove what, Dechert did not have evidence sufficient to prove what Kiribati said
And that's a
it did.
disputed issue of
That
fact,
is
isn't
a
it?
hotly disputed issue.
So
Let's
why do you
assume
get
it's true.
summary judgment then?
Well, this is the way the summary judgment played out. We received Professor Lubsdorff's affidavits.
This is all before Lubsdorff. Put aside Lubsdorff.
Well, I mean,
Lubsdorff wasn't
well,
there at the time.
we-
have a court, you have the appeals court of Tahiti saying, we think it's important to get this information,
Yes.
and you blow them
Well,
off.
the question went from Justice Hines went to why we did what we did below on a motion for summary judgment. And the reason we did what we did, which was to focus on causation, was because we anticipated a battle of the experts, and knowing that a court, if it had a whiff of a disputed
Well,
fact, would deny
articulate
it.
to me why any
Yeah.
lawyer would do that.
All right, the test to be applied in this situation is not what the actual court of appeals that heard this case would have done. It is what a reasonable court of appeals correctly applying French law should have done.
No, I think you're just not answering the chief's question here. I think the question is there any standard of care that would say it was all right not to comply with that court order?
Yes,
And you're saying that there is,
yes, I will say this.
And why was it, do we know, that your client did not comply with that order?
Let me explain. First of all, the record below is not as fully developed on the standard of care as I wish it were now, because that's not the basis for our motion. But I can say this about what I'll describe as the disputed evidence. It was not only legally irrelevant, it was factually deficient, and submitting it would likely have caused more harm than good, although it would be pure speculation to try to figure out what the actual court of
And
appeals.
where is that defense in the record?
Well, let me explain. Again,
No, try
at the
that.
summary.
Where in the record are we going to find anybody who said that there was wisdom in not furnishing it? I thought that that's simply not there in the record.
Well,
Show me
it
where.
wasn't the focus of our motion on summary judgment,
Not in the record.
so we didn't know, but there is evidence in the record in the court's decision that will inform the court why this evidence was not relevant and why it does not prove what.
But you're missing the point. I mean, so let's assume that I'm an idiot judge, and I'm about to, and there are two ways you can win. You can win either because I accurately apply the law, or you can win because I have misunderstood the law, but factually you can still address my misunderstanding, and you can win even though I may be wrong. And you have in your hand arguably the papers that can say, I can win even if the judge is wrong, and you don't give them to the judge. Why would any lawyer do that?
What I'm trying to explain to the court is that the papers that I had in my hand would not have accomplished the purpose that the court is suggesting.
So what? You give it to them.
Well,
Let them decide if it's what they want.
this is what Dechert did and why. First of all, in its November 2009 brief, it made the correct legal argument. It said, given the validity of the assignment, Kiribati stood before the court in dual capacities, as an assignee from Lloyd's asserting its subrogation rights and on its own behalf. So there was no possibility even of double recovery. So the interim decision comes out. Kiribati's already made that argument. It's been rejected. So it has a decision to make. Do I make the argument again? It's already rejected it once. That's not likely. So what do I do? For the reasons I can explain, submitting the evidence that is suggested by Kiribati would most likely have resulted in the same result, disallowance of the claim. So what Kiribati did is, instead of focusing on consideration, it focused on the absence of any possibility of double recovery, because that was an argument that may have permitted the court to uphold the entire award.
Isn't this something a jury should decide?
Well, it was in the Court of Appeal.
I know, but whether or not they comply with the standard of care, that seems to me to be something the jury should sort out.
Well, again, our argument below was, even assuming that Kiribati was somehow negligent in submitting this evidence, even assuming that, because the evidence that was requested by the Tahitian Court of Appeals was irrelevant as a matter of law, and we have an expert that testifies to that, and their purported expert doesn't differ.
So you're saying it's because the Tahitian court got it wrong, ultimately?
I'm saying that because...
And that's all that matters, and because we have to look at what the right decision would have been, you're off the hook.
That is correct. The
Well,
standard...
that's the problem.
Yeah, on policy grounds, that's just not what
Well,
lawyer.
let me-
I mean, wait.
I'm
You know,
sorry.
that's what a lawyer does. A lawyer manages the risk of error, that a court is going to make error. And that's the lawyer's job. That's what they're paid for. That's what they're trained to do. The lawyer can say, yes, that judge is stupid, but I'm going to do what the judge wants me to do. And if the lawyer doesn't do that, and there's a mistake that could possibly, I mean, I'm not sure that the plaintiff has to show precisely that it would have cured, as long as the lawyer's non-action contributed to the problem, how can we let the lawyer off the hook?
Well, what I'm saying is that, as a matter of French law, Dechert's failure to submit any evidence did not contribute to the problem, because when looking at what a court of appeals properly applying the law would have determined, that evidence, as the trial court found, had absolutely no impact whatsoever on the ultimate outcome.
Well, wait a second. Counsel, I thought just said that the final decision made it clear that the non-receipt of that kind of information was dispositive, or at least in part dispositive, for why the client lost. And even if that was error on the part of the judge at the final decision, it still was the reason why the client lost, wrong or right.
Well,
And you're saying that, well, if that decision was wrong, that's what we look to, because it should have been the other way, and if it was the other way, then it didn't make any difference.
No. First of all, in terms of the timeline, the error in this case occurred in April of 2011, when the court, in its interim decision, instead of affirming the judgment,
That was an error.
decided that this evidence was relevant, when in fact it was not. To say that had Kiribati submitted that evidence, the court would have done X, Y, or Z, is pure speculation.
Don't we know that from the final decision?
No, we don't.
Well, okay, there's a
Well,
distinction that, your sister obviously disagrees with. We'll have to go back and take a closer look at that. But if you look at the final decision and she's right, then what?
Well, again, I think you have to look at the quality of the evidence. I mean, we did not dispute below that there could be an argument about whether there is a breach of the duty of standard of care. We frankly think that if this case were to go back down, we could establish beyond any dispute that there was not. But leaving that aside, what we argued was, even if Dechert should have submitted that evidence was immaterial to the consideration that would be given by a reasonable court properly applying the law. And the only reason that decision took place was because the Court of Appeals made a legal error. And
But do you apply that reasonable court standard to ambiguous situations where it's not quite possible to zero in on it? But this case is different. You don't have to speculate. Reasonable standard makes sense if reasonable people could disagree about what the court might do, but here the court is telling you what it would do. So we're supposed to overlook that and then go apply a reasonable court standard to that situation?
Well, the cases that are cited, the superseding cause cases, which we don't think are applicable, that are cited by Kiribati.
By the way, did you argue that before the judge in the
Yes.
Superior Court? You argued superseding cause?
No, I did not argue
Okay.
supersede. What I argued in the trial court was that a reasonable Tahitian Court of Appeals would have affirmed the subrogation award with or without the disputed evidence. The trial court accepted that argument on page 20 of its decision and found that had the court properly applied the law, the disputed evidence would have had no impact whatsoever on the outcome. Those two findings constitute an argument that Dechert's conduct was not a cause in fact of the harm suffered by Kiribati. And if there's no factual causation, there's no cause to be superseded by an error of the court.
But you agree that a judicial error is not always a superseding event?
Well, there are two schools of thought. One set forth in Section 452, Paragraph 2 of the Restatement Second of Torts, was relied upon by the trial court, which essentially says, if you have a situation where a third party assumes responsibility for the ultimate outcome, then foreseeability is not required. That's what the trial court found. We don't think the trial court even needed to address the issue of superseding cause. There are the second school of thought, represented by the cases cited by Kiribati, which say that a lawyer can be found liable despite a legal error if he either contributed to it or if he could have taken steps consistent with the law that would have caused a reasonable court properly applying the law to rectify the error. That's not what Kiribati is suggesting
I
here.
think you're adding something to that. I don't remember ever seeing the words that you add to that test. It just says that if the lawyer, doesn't say consistent with the law or any of that stuff. It just says if the lawyer contributes to that. See, that formulation gets you back to where you started with this case. But that's a problem for your argument, that the lawyers in this case didn't do what they could have done.
What Kiribati is suggesting here is that Dechert should be found liable for malpractice for failing to make an erroneous legal argument.
But that's what the court was looking for.
Your Honor, that is why the law applies an objective standard. A plaintiff is entitled to recover based on what should have happened.
Yes, but what
not
could have
based on what
happened-
could have happened.
But what should have happened, don't you think, would have been to have submitted those materials with an argument in the alternative, that because this is what the court requested, even though this is not the way the law should be construed, we nonetheless supply the information that the court requests.
For reasons I'd be happy to explain, if that evidence was submitted, it is our belief, albeit speculative, that the Court of Appeals would have done exactly what it did.
That would be helpful. Can you just briefly say
Sure.
why you think it would?
If you look at the interim decision, the court explains why it wants evidence of consideration. And it says it needs to know the actual price of the transfer. Those words are in quotation marks. The reason they're in quotation marks is because in the prior page, the court quotes Article 1699 of the French Civil Code that contains those words. What that provision says is that if a defendant is sued by the assignee of a claim, the defendant can settle that claim by paying to the plaintiff the amount of consideration the plaintiff had paid for that assignment. So if Dechert was only to submit evidence that showed $100 of consideration, for example, there was nothing to prevent the Port of Papeete from invoking its rights under Article 1699 and buying off that claim for $100.
Is that what the evidence was, that it was $100?
No, I would say that the evidence that Dechert could supply was zero. And the reason for that is it could not submit the document that contained the releases that Kiribati refers to because it was subject to an obligation of confidentiality to Lloyd's. That agreement said it could not be introduced in any legal proceeding except one seeking enforcement of the provisions between the parties. Dechert's expert said that confidentiality obligation prevented Dechert from offering that. So Dechert had no evidence even of the releases that Kiribati talks about. Now going to the evidence of legal fees paid. Lloyd's of London exercised a unilateral right to terminate the April 2004 litigation agreement effective December 15, 2004. Kiribati claims that amongst the evidence that Dechert should have submitted is a payment of $145,000 made 5 years later in 2010 in estimates of future legal fees. None of that was Lloyd's obligated to pay at any time after under the April 30th agreement. In fact, the April 30th agreement didn't ultimately
So are you saying there was no evidence of consideration?
I'm saying the evidence that Kiribati suggests that Dechert should have been submitted does not establish consideration. I'm saying that had that been done, it is highly likely that the court would have looked at it and said, we don't find consideration, we reject your claim, just as it did. It's also important to note the April 30th litigation agreement, which is what I call it, it didn't obligate Lloyd's to pay 50%. It was a loan agreement. It obligated Lloyd's to advance funds for the payment of 50%, subject to repayment with interest out of the first dollars of any recovery.
So here's the thing. This is what I guess we're having some trouble with. Lloyd's did not give up the right to get its indemnification for nothing, right? It gave it up because it wanted to get something for it. What did it get?
Well, I mean, what it got, in fact, is different from what Dechert was able to prove in the Court of Appeal. What it got, in fact, was the policyholder release that Kiribati mentioned a moment ago, which claimed to release unfair insurance practices claims that it had against Lloyd's. But again, Dechert couldn't introduce the document that contained that release.
So why isn't that a bar to summary judgment if you have a dispute of fact about whether you complied with your obligation?
Well, again, we didn't move for summary judgment on the standard of care issue. We moved on causation based on the fact that applying the objective test.
Well, they opposed it on that ground.
Yes, they did, and the motion was denied.
That's an issue of fact.
Well,
For-
as to
for-
their motion,
Well,
yes.
yeah, I mean, that's what we look at to decide
Yes,
if
I
the
agree.
judge properly granted summary judgment to your client.
I agree. Well, I would put it differently. That only becomes an issue if you find that the trial court did not properly find that Dechert's conduct was not a cause in fact because of the legal error. If that's not the case, and if we had to go back to the trial court, yes, yes and no. Yes, there are factual disputes as to the relevance of the evidence, but the relevance of that evidence would have to be established through expert testimony, and Kiribati does not have a qualified expert. Professor Lubsdorff, if you read his affidavit, his books, his articles, has no experience whatsoever, even in the two areas where he professes expertise, legal ethics and French civil procedure. And by the way, even if you accepted that he was an expert in those areas, that doesn't qualify him to testify to what a French commercial litigator should have done under these circumstances in a trial in Tahiti, nor does it qualify him to analyze the substantive French law that needs to be considered in determining whether there was causation. So even if you accept his affidavit, he's not qualified to render the opinions that he rendered in this case. And absent that testimony, Kiribati cannot get this case to a jury.
So I gather that you reject the concept that a foreseeable legal error is a grounds to find negligence by an attorney, that where a judge makes a foreseeable legal error, which could have been addressed but was not addressed by counsel, that is not a grounds for liability.
Two things. First, it's a policy choice. The trial court chose one school of thought.
No, it's illegal. It's a
advocates, and I
legal
understand.
standard.
I understand. But even if you accept that a lawyer can be held liable for a foreseeable
For the failure
mistake
to address a foreseeable legal error.
Correct. But that's only if the lawyer somehow contributes to it. And if the evidence was irrelevant as a matter of law, they did not contribute to the error if you view it from an objective standpoint of what should have happened had the court properly applied the law.
Okay, but I'm not speaking about whether the lawyer contributed to the legal error. I am saying that the failure to address what would otherwise be a legal error, is that negligence on the part of an attorney?
If the failure to address it is consistent with a proper application of the law, not if the failure to address it is buying into the court's error,
Okay, so
when you
you're-
have
so-
already made the proper argument and preserved it for appeal.
So you're rejecting the Lenkian alternative that where a judge says, I think I need this information in order to find for you, that you have no obligation to say, Judge, I think that is an error as a matter of law, but if you are right, here is the information which would address your concerns, so we would still win.
That scenario is kind of like the Stanfield versus Neuwirth case, the Texas Supreme Court case. In that case, the trial court made an error in finding that there was sufficient evidence of agency, and the defendant was tagged with a verdict based on an agency theory. The plaintiff said, you, defendant lawyer, could have introduced evidence at trial of two valid legal defenses that would have rendered that decision immaterial. That issue was preserved on a motion for summary judgment, just as it was preserved by Dechert here in making the correct argument. And the Texas Supreme Court said that is too attenuated. First of all, the decision not to pursue those defenses was a trial strategy within the reasonable discretion of the lawyer. And number two, it shouldn't have happened anyway because the court made a mistake on agency. That is more of the situation that we have here.
But those were issues decided at trial in Texas, I gather.
Those are issues decided at trial. Well, no, on the
Are you-
Court of
are you
Appeals
saying-
found.
Are you saying that the issue of attenuation and the issue of whether or not it would have sufficed are matters sufficiently clear in this summary judgment record that we can find for you on this record?
I do. I think, given the proper application of French law, it is abundantly, and, by the way, there's no real dispute as to French law. Even Professor Lubsdorff doesn't say that the Court of Appeals was right. And in fact, he says that the French Supreme Court might well have upheld the analysis of Dechert's expert. So there's no real issue about French law. And there's no real issue that once the assignment was found to be valid, there could be no issue of double compensation under French law. Our expert testified that and did so in a clear manner. So if you accept that, the conduct alleged to have been malpractice in this case is not a cause in fact of the harm alleged to be suffered by Kiribati.
Okay, thank you.